The defense attorney wants to know how much pain medication you take on a daily basis. Do you have to tell him? He wants to know how many times a week you take Tylenol for your pain. Do you have to tell him? He wants to know how much narcotic pain medication you take on a regular basis. Is this something you have to share with him? You want to know the answer? Come join me in this walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, when you bring a lawsuit seeking compensation for all the harms and losses and damages for injuries caused by someone who is careless, whether it's an accident case, whether it's a medical malpractice case, you now open up your medical condition to the defense's questioning, which means when the defense asks you these questions during a pretrial question and answer session known as a deposition, or it's also called an examination before trial, you have an absolute obligation to share those details with the defense attorney. Otherwise, how else are they going to know what injuries and problems you really have? It's one thing for the attorney to put down in a set of papers exactly what your injuries are. It's another thing for the defense attorney to get copies of your treating doctor's medical records to learn what complaints you made to your treating doctor and how your treating doctor is actually treating you for those particular problems. But now he will have an opportunity during the course of your lawsuit to ask you directly questions about your particular injuries. And not only will he ask you lots of questions about what things you can and cannot do today and what problems you have as a result of his client's carelessness, but he is entitled to probe. He is entitled and will probe about what actual care and treatment you are receiving now for the injuries that you sustained in this case, including medications that you are receiving to deal with the pain, medications that you are taking in order to go ahead and treat the problems that you've experienced. If you now all of a sudden get shy or turn around and say, I'm sorry, but that's very private, I'm not sharing that information with anyone, guess what? Your attorney is going to turn around to you and say, excuse me, Mr. Jones, you are required to answer that information. If you fail to do so, you are now preventing the defense from learning the details about these particular claims, and now they're going to be at a significant disadvantage to verify whether or not these claims are actually true. And if you hinder and prevent them from learning about this information, you're basically spiting yourself. Why? Because this is part of your claim. It's part of your pain and suffering claim. And if you don't disclose this information to the defense, they will go back to the court, to the judge, and say, Judge, Mr. Jones refuses to share this information with us. We have this information in his medical records, but we have no clue whether or not what he's claiming is true. The only way is to have you, the injured patient, the injured plaintiff, answer these questions directly to confirm that the problems and the pain and the medication that you're taking are all related. And if he fails to answer this information, we, the defense, are at a significant disadvantage. And you know what? He'd be absolutely right. And the judge would be well within his right to render an order that creates a problem for you, that basically says, okay, since you, the injured patient, has refused to provide this information, I'm going to strike this part of your claim. And now when your case gets to trial, if it gets to trial at all, you are prohibited and prevented from bringing this up. Why? Because you failed to give this information to the defense attorneys at the time that they were trying to learn about it and to verify it for themselves. So to go back to the original questions I raised at the very beginning of this video, will you have to answer questions such as, how often do you take Tylenol? How often do you take narcotic pain medication? How often do you take medical marijuana to treat the problems? The answer is, you do have to answer those questions. Failure to answer them will lead you down a path where you likely will not want to go. So why do I share this quick information with you? I share it with you because some people get all upset learning that they will have to share medical details about their most intimate lives, especially about the amount of medication that they're taking, about the amount of pain medication that they're taking, and they simply don't want to reveal that information. And you know what? That's perfectly okay if you don't want to reveal that. But recognize now that failing to disclose this information will prevent you from bringing this up at the time of trial and prevent the jury from evaluating that part of your claim which seeks monetary damages as a result of all the pain that you have suffered following this particular injury or malpractice. You know, I recognize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.